Good morning, everybody. Thank you so much for joining us for our latest CPD Live. This morning, we have got Lucy Marlow with us, who will be going through 101 legal considerations for small businesses. So, Lucy, over to you.
Thanks, Sam. Yeah, so I'm an IP specialist. So there are lots of considerations as business owners on the legal side, everything from, corporate, your commercial contracts, employment. And that's something that my firm does. But as I'm an IP specialist, and as I consider IP to be very important and valuable to your businesses, that's what I'll be focusing on today. And during this talk, I'll obviously focus on the rights that are most relevant to your businesses. And I often find that people come to me and they think that if they're not a tech business, then IP probably doesn't apply to them and it's not really that relevant. But actually, with all of your businesses, IP is a really important asset. Oh, sorry, before I even started, I should have said that, some of these points that I'll talk through, they might be a bit complicated or you might have burning questions. So feel free to raise your hand. And I don't know if, Sam, you're able to pick up on that, because I'll probably be so in the zone, I might miss it out. But there will be questions at the end. But feel free to ask any questions, because I also think that helps it bring it to life and we can try and apply it more to your industry and the issues that you might face. So as I've mentioned on this slide, because IP is so multifaceted, there are so many rights that will exist in your business. I mean, the two main obvious ones will be copyright in your websites and your materials, your branding with trademarks. But the tricky thing for a business is that audit piece and sort of understanding what it is that you have, because often you'll have it and you might not even know it, and you might not be adopting best practices as to simple things that what you can do to maximize the value of your business. So there's a little bit of that training piece that goes around it, but also that what flows from that is also being just a little bit more sophisticated and thinking about whether actually there are some rights that we might want to apply for example, a trademark. That's something that doesn't just automatically arise. You actually have to protect that with a registration, and also just being a bit strategic around these things, like thinking about which markets are important to you, whether you're going to expand. All of these different things are what we help our clients with. And then the other thing that I will touch on in this presentation, which goes to partly why IP is important, is also what to do in that copycat situation and like what routes are available to you if you find someone copying you. That's the litigation and enforcement piece that I've mentioned. So just as an overview, on this slide, I've just set out the main IP rights that are likely to be relevant to your businesses. Brands are at the top because everyone has a brand and that can be protected with a trademark. Copyright, because naturally, I'd imagine you've got many copyright materials within your businesses. You'll probably have particular ways of doing things. You'll have your own practice papers, sets of materials. They're all subject, and methodologies, they are all subject to copyright that you will own. Database rights, they're also likely to be relevant again. You'll probably have lists of your tutors, lists of your students, and these are things that are really important, that you know that they're an asset and there's something that you can protect. Just to cover everything off, I have mentioned designs. That's less likely to be relevant to your businesses because they more so affect the look and appearance of a product. Patents, they cover really groovy technical inventions. They could be relevant to some of your businesses if, for example, we're dealing with software, but I'll come on to that a little bit later. But I think the point to take away from this is that there's so many layers of IP rights, and they will arise in your businesses. So it's just important to be alive to that. Sorry, I haven't moved on to the next slide. So I wanted to just start off with brands, and this is like obviously a showcase side, just demonstrating the value of brands to businesses. And I always give a good example of Twitter and how that sold for $44 billion. And really, a lot of it was quite a simple idea, but the success really did come from the brand itself, and that was a highly valuable asset. Now, I'm not saying that our businesses here are at the Twitter level, but that just goes to show how important it is to properly protect your brand. And a thing that a brand and a trademark gives you that adds value is that it's a monopoly right. So what we mean by that is if you have a trademark and it will be registered against certain goods and services, then the power of that trademark and that certificate effectively that you'll get from the UK Intellectual Property Office is that if anyone else uses an identical or similar brand, and that similar piece is important because people often think it has to be identical, but it doesn't. And it could be identical or similar goods. So again, that similar piece, people often forget that. You can take action against them. So, and even sometimes if you've got a lot of reputation in your mark, even with dissimilar services, you can take action. So that is one of the most significant assets that any business can have. Now, what I often find as part of my practice is that people, especially if you're a startup or, you don't have a massive legal budget, then you might be thinking, well, what's the point? Why would I think about filing a mark? And the key thing here is that if you ever do need to enforce your brand, there are other rights, and I'll come on to that. You've got an action of passing off in the UK, but basically it's much harder and more expensive if you don't have a trademark to try and stop others from using similar brands, within your territory, within your scope. And so although, yes, it will cost a little bit more perhaps to file and secure a trademark, it does mean that if you have to enforce it in the long term, it will be cheaper. And another thing in terms of enforcement is that nowadays we see a lot of online infringement. So, it might be the case that it's a cloned website or someone else is just using your brand online. And there are a lot of online takedown services. So even writing to Google, for example, and asking them to take down another website, if you've actually got a registered right, then these takedown processes basically are a lot easier to engage with if you have a registered right, rather than having to show, for example, if you don't have a registered trademark, exactly how you've been using your brand and establishing the alternative, which is an action in passing off. So long-term cost savings, cheaper enforcement, and it can act as a deterrent against copycats because you can then use the R in a circle symbol, and that indicates that you've got a trademark. It sends a message that you know what you've got and you're prepared to enforce your rights and stop others from copying your branding. Looking on the money side of things as well, we do find that, especially if you're trying to attract investment, having registered rights that can help with attracting investment. I know now there are quite a few banks that even will loan on the back of IP. So NatWest is one of them. And if you are ever gearing up for an exit, showing that you have thought about your IP and evidencing what you've done to protect it, having registrations, that can all add to the value of your business when it comes to exiting. I've mentioned also on this slide about generating revenue, and that can come from, for example, if you operate a franchise model and you wish to allow, other third parties to use your brand, brand protection and having, clear guidelines on that and having a registered trademark, helps you with, with going down that route. Is everyone with me? I feel like I'm doing a lot of talking, so please fire away with any questions. I've popped on this slide 2 random pictures of birds, and it's not as kooky as it sounds, but I just popped that up just as a little example, because this is actually a real case that went to the High Court, and the symbol on the left, you probably recognise, it's Jack Wills, and the logo on the right, that was adopted by House of Fraser, and House of Fraser were found to have infringed Jack Wills' rights in this case. Like, you might look at it and think it's not similar, but when we assess similarity, lots of different things are taken into consideration. So in this case, it was looking, because it's not a word mark, so we wouldn't look at how it's pronounced, the oral similarities. We'd look at conceptual. So here we're looking at accessorized animals. You'd also look at, the visual impression of these particular marks. So I just want to give that as an example. When I made the point before about it doesn't have to be identical, this is what I'm getting at, and this is a good example of it. And I bet you'll never look at Jack Wills again when you go into the shops. Now, this slide demonstrates the point around clearance searches and why they are important. So in an ideal world, and we all accept that doesn't always exist, but ideally, before launching a brand, you'd have an idea of what you want your brand to be, and you come to someone like myself and you'd say, okay, if I launch this brand, am I going to get it registered, and might I infringe anyone else's rights? Now, those are 2 things that we can help you with. So firstly, not all marks are capable of registration, because the Intellectual Property Office have some rules around this. And for example, one requirement is that then the mark shouldn't be descriptive of the goods and services that you're going to offer, and it needs to be distinctive, and I'll come on to that. But also, third parties can oppose your mark if their mark is similar. Now, let's say you don't even bother with the trademark registration piece, the reason why these clearance searches are also important is because if you've been using your brand and someone else has an earlier right, so they've been using it basically before you, or they have a trademark which predates yours, they could claim that you're infringing, and they could claim, sorry, I just saw Juliet's comment, sorry, I'll answer that in a moment. They could claim that you're infringing and be entitled to financial compensation. So that could they could either get damages or an account of profits, and that would be where an account of profits, if they went down that route, would mean that you'd have to divest yourself of your net profits. So that's pretty scary. And that's why just taking, it's almost like an insurance really, taking these steps to clear your mark before your launch, or even if you are using your mark or you've just started, just clear it to check what the risks are and then file. That's best practice. Now on this slide, I just gave a couple of examples just to demonstrate why clearance searches are helpful. So for example, if you had a business involving online tutoring and you wanted to call yourself Apple, well, a clearance search would show that Apple have education services covered. So that would be really high risk. And we might want to think twice about that. But there are others that are probably on the lower end of the risk scale. So at the bottom row, I've got this example of, by the way, I've just made these up, Cheddar Grove Tutors. And if someone else had Cheddar Grove Reality, but that was in a completely different sector that's not remotely related to education, like real estate services, that would be much lower risk. So that's the value of having a clearance search before you launch your brand, or even if you've been using it for some time and you're just worried about the risk, this is something that we can help you with. Now, in terms of trademarks themselves, I mentioned before about the importance of having a distinctive mark and one that stands. Oh, hang on, I forgot the question. Let me just go back. I know there was a question. Juliet, I believe I wouldn't be able to register my business name as a trademark as it includes the name Cambridge. Yes, yeah. So that's the other thing, is that marks which refer to a geographical place, that part of the mark is potentially not registrable, because again, it's the whole point about this is that the office believes that common use words that are quite descriptive of services or references to the quality of the services, like excellent tutors or the geographics, those are all grounds, absolute grounds, which the Intellectual Property Office could refuse a mark for. So that you're right there, Juliet. Julia, you say a business name that includes your own name is probably not registrable. Julia's study space. That if you include your own name, that potentially is registrable. You can register a mark. David Beckham will have David Beckham registered, for example. Usain Bolt, you can register your own name. If someone, I think the confusion that arises there is that there is something called an own name defense. So someone else was called Julia Delamar, and they wrote to you saying, you're using Julia Delamar, you need to stop. You would, and they have a trademark, you could say, well, actually, that's my name. And that can be a defense. So another one is, could I register Danny Long Tuition? Yes, but if the word tuition here in trademarks, and I suppose this applies, there's probably quite a few people on the call thinking about this, is that if you're going for tuition for educational services, that part of your brand, that part of your word mark, tuition itself, the office might refuse it on the basis that it's descriptive of the services that you're providing. But even if they didn't refuse it and you got it, when it comes to enforcing your mark, you have to rely upon the dominant and distinctive parts. Now, what would happen in that case is that the office, the party that you're enforcing your mark against will say, well, you can't compare your mark to my mark where the word tuition is included, because that's not distinctive. So then we'd be comparing, say, Danny Long, ignoring the tuition bit, versus whatever the other side is using. So that in that case, Danny Long would be a much better trademark because tuition is not distinctive. The other, just adding to that, is with a trademark, there's no point in just having your trademark unless you really do keep that monopoly and make sure that others don't encroach upon your territory. So if you have a word like tuition, yes, it partly conveys to the public what you're doing. So I can see that attraction in having the word tuition. But the problem that you've also got is to enforce your mark. There'll be loads of tuition businesses out there. So it would always cost more to stop others from using something similar. So that is something to think about. Just having a look at some of the comments. I tried a few years ago, and and it was rejected. Yeah, and that's the, so the mark up your grade, that would probably have been rejected on the basis that it's alluding to the quality of your services and what you do. Like, come to you, tuition services, better grades. That's probably why they refused it. What I would say, just sorry, adding to that, is now we're getting a bit technical, but sometimes you can get these descriptive marks registered if you can show that you've been using it so extensively over time that it's actually acquired distinctiveness. So it's really well known in the marketplace with your business. So that means that the trademark is capable of acting as a badge of origin. So you see up your grade and everyone knows it's your business and that you're the origin behind that business. So it isn't impossible, but it's harder. One more question. Salute, and apologies if I've butchered that Spanish pronunciation, Spanish. I would be registering the word. Yes, so that example, Soltura, I hope I pronounced that right, as a trademark, that potentially, to me, I don't know what that word means, but if it does mean something though in Spanish, that again alludes to the qualities of the services, or if say that meant education in Spanish, that could still be rejected on absolute grounds by the UK IPO, potentially. But that one looks more promising. A good example of what could be registered would be, let's say, let's forget that Apple exists, but say Apple for education, or even Apple as they have a mark for computing. Yes, Apple is a common term, we all know, but it's not common and it doesn't describe computing or software, but it does describe fruit. So it'd probably be refused if you applied it for a greengrocer's, but it be allowed for software. Okay, just going back to the slide here. So with trademarks, as I mentioned before, common ones are word marks, logos, sometimes slogans. You've often got your core business, so your core brand, and sometimes you can have, if you've got different service lines, you can also register your sub-brands as well. I mentioned before the importance of having a really distinctive mark. And another thing to consider as well is the jurisdictions that you like. Okay, for now you might be focusing on the UK, but if you want to in the future expand it, the trademark system operates on a territory by territory basis. So if you're about to launch, for example, this is like the ideal situation. What we would do is we would clear your mark covering all territories of interest to you, so that you know that you can launch in those countries and not face any obstacles. Because what you don't want is to have a patchwork of rights where, okay, you've got your UK brand, but in the Middle East, you can't get trademark protection. So you can't keep your uniform business name globally. And that's where, again, prior rights searches can help you. Now, I mentioned before about once you've got your trademark, great, but actually there are a few extra steps to think about, and that is watching services, which is typically infringers will try their luck and apply to the UK IPO for a trademark, and it's possible to set up, and we do this, watching services, whereby if something similar is applied for at the register, we will notify you of that. And that can really help in that it will provide you with an opportunity to stop that infringement quite quickly. It's much more expensive and much harder if another business has been coexisted and has launched and plugged lots of money into its brand for some time and been operating for some time, and then you go up to them and say you want them to rebrand, they're more likely to put up a fight. So it'll be more expensive to get them to stop. So that's why one of the main benefits of having watching services is because you can nip it in the bud at a much earlier stage. And as soon as we find something similar, we can ask them to stop progressing their trademark application. And even if we have to take it one step further and actually oppose their application at the UK IPO, that's a much cheaper, more cost-effective forum than the courts. So it basically is a really good strategy for enforcing your rights to use watching services. Just a couple of top tips to be aware of is that your trademark will need to be renewed. They need to be renewed every 10 years. And if you don't use your mark beyond the first 5-year period, there is a risk that for the goods and services that are covered by your application, there is a risk that third parties can seek to cancel, revoke your trademark. So it's always good practice, even before that, even in the first 5 years, to always keep evidence of how you're using your mark. Now, that kind of evidence that would help. And again, if you don't have a trademark, and in the future, let's say you have to enforce your brand against someone else, that would be a passing off claim. And you'd need to be able to evidence the goodwill in your business. So my top tip there would be always try to keep evidence of your use. So sales records, invoices, but actually where you're displaying your brand. It's really important that we can show how you're using your brand. Marketing materials, that could be like catalogs, flyers, brochures, all the digital metrics that we now have at our fingertips. So, dated website screenshots, your sales, web traffic, all the good stuff that you can find on social media. That's all really helpful. Financial data, your turnover, your accounts, your market spend, awards. I mean, that I've given off a whole list of things. But if you can, just knowing that keeping that evidence is important is a really useful tool moving forward. And the other thing that I often find, another top tip, is just to use your mark consistently. I often find that businesses, they might have a trademark, but they use subtle variations and a myriad of different variations, permutations of that particular brand. If you do that, you're reducing the goodwill in your core brand. So identify your brand and use it consistently. So the final piece of the puzzle, which I've already alluded to, is if you don't have a trademark, what do you have? And you still have some protection, and that's in the form of passing off. So to succeed in a passing off action, you would need to show what your brand is, the goodwill that you have generated in that brand. So all the evidence that I talked about before, that's all relevant to establishing goodwill. If someone else is using a similar brand, we need all the evidence as to the misrepresentation that they have caused. And then we need to show damage or a likelihood of damage. So, for example, a loss of sales as a result of the other infringing party's activities. So I've just outlined quite a lot of hoops that you have to jump through, which shows why actually just having a trademark is much more straightforward and easier. And I've just set out on this slide as well, just the general point, which is that you don't have to oppose someone that's got an identical mark with identical goods or services. It can cover similar as well. But okay, so this is another intellectual property right that's very relevant to your business's copyright. It can cover a whole range of things, but in your case, probably the most relevant types of works would be your text, so, and also images and flow diagrams, graphical representations that no doubt you've created and form part of your core materials and also your websites. Now, my little picture's not, there we go. The key thing with copyright that people sometimes get confused about is, does it need to be registered? It doesn't need to be registered. It arises automatically. It just needs to be original. So it needs to not be copied. And you can sometimes, that can be the tricky part when you're enforcing your rights. And for example, if you've got a detailed methodology or way of tutoring that you disseminate to your tutors, for example, and that's something that you have, that you've got lots of sketches on or lots of different permutations to show the evolution of that final document, that is important evidence to keep, to show for your key copyright protected works exactly, how it arose from an original idea, you recorded it, and how it's evolved over time. And if you can also date stamp that to show, like when you first put pen to paper, and then all the various other times when the idea evolved, that's really helpful. It's not a right that requires registration in the UK. As I said, it just arises automatically. And another good deterrent here is to put a C, you've probably seen this before, a C in a circle, the name of the owner of that copyright and the date. So in my case, it would be, I think I've got it on the next slide. No, I haven't. It would be, C circle, Lucy Marlow, 2016. That would show that I own the copyright. So on the next slide, I've just got a little bit of information about like what copyright infringement looks like. And there is a test for it, and it all is around copying, and it doesn't necessarily require the entire original works to be copied. It cannot be copying of a substantial part of that works. And there's a whole bunch of legal tests around that. But the point is that it's more of a a qualitative test rather than quantitative. So you wouldn't necessarily look at this slide and say, well, you know, the right-hand side of it, 50% of that has been copied, so therefore it amounts to an infringement, because actually that right-hand side of my slide, for example, doesn't include a lot of text, and it's not, as I said, it's qualitative, like has a substantial part being copied. So, but that again is something that we could help you with. Now, to make sure we're all awake and we're still following the flow, I've just given an example here of how your IP rights might be relevant in a real world situation. And this is website cloning, because I'm aware that this is happening more and more, especially with AI. And actually, it's really small on my screen, but on this slide, you can see that potentially several rights have been infringed. You've got the trademark, that's so on the left-hand side, that's the genuine website, and on the right, that's the cloned infringing website. So obviously we can see here the brands have been copied. So in that case, you could rely upon registered trademarks. The general get-up of this website, that could qualify for passing off if you've got good, because you'd say that you have goodwill in that particular website. And this cloned example, it's very similar. So it creates the misrepresentation that the origin of those services is the business on the left, when it's not. So there we've got the misrep, so we've got a passing off claim. Look at the website, you've got graphics, you've got images, all of that would be, and so there's no actual words really that are substantive, but potentially if there was some text, you'd have copyright in that. So we'd have a copyright claim. You've also could think about other claims, such as, I'll move on to the next slide, which this just sets out in a bit more detail what those claims are. But for example, you've also got the tool of, if you had a trademark, that you could use the domain registries, Nominet, and for global domains, ICANN, where we could write to them and say, we have a registered trademark. This cloned website incorporates my trademark, so you need to take it down. That's one tool that we would have. You've also got, potentially, we find in these cloning cases, it might be that you've got lots of data on your website, and you could have, for example, client lists or customer lists. I suppose that's not likely to be available online. But if you do have these kinds of databases and they've just been copied, again, that's another IP right, database rights that we can enforce. Your website should have terms and conditions and should preclude scraping. So if that's what they've done, then again, breach of contract. So, and naturally fraud, that's another angle. So the point here is basically your IP can be a tool to stop these kinds of website cloning scenarios. And there are lots of options here. So we could write to the registrar, so the owner of the website, the host, and ask them to take it down. I've mentioned about domain name disputes. We could write to Google and request that they delist. With Google, as I said before, if you've got a registered trademark, it makes it so much easier. We can try and disrupt the payment provider by writing to them as well. So, and a normal cease and desist letter to the party behind it. So there's lots of ways of stopping this. And just to bring everything together with an IP case, the main remedy is to stop the infringement. So that's interim injunction, but also you are entitled to financial compensation. So if you've suffered, either you've missed out sales or they've unfairly profited, we can go after them for that. And in the case of domain names, we can also get the domain name transferred to you or suspended. So I've now just got a couple of rights that I'm conscious we're running out of time that I will quickly run through. But a key right with all businesses that sometimes is overlooked is confidentiality. So, for example, your list of tutors that are on your books and your students, they're all quite confidential. Even if you've got guides on your teaching methodology, for example, again, that's quite confidential information. And the way you think about that is that if someone else got their hands on this, would I, and a simple way of thinking about it is, would I be upset? And if you would be, then it's likely to be confidential because it would give the other side a competitive advantage. And in that situation, in an ideal world, nothing would be online and it wouldn't be electronic, and we could siphon it all off and put it in a safe. But obviously it's a bit different nowadays. So we just have to think about different ways of preventing misappropriation. So, for example, password protection, training your staff on what is important and what they, or your team, on the fact that they, for example, can't print things off and take them home. Look for practical ways to make it really difficult for them to misappropriate your confidential information. When we're talking about organizations as a firm, we often have this bad leaver scenario where someone that you trusted has tried to steal some of your confidential information and misused it and launched often a competing business. There are things that we can do to help with that. We can help put in place like bad leavers protocols, but a couple of things to think about is monitoring. Obviously, you'd have to update your policies to make sure you have the rights to do that, but a lot of businesses will monitor use of devices when someone basically resigns. As soon as someone resigns, they'll put in place this protocol to monitor what they're doing. So if they're suddenly printing off a million things or accessing your precedents, that's an alarm bell. If someone leaves, you can also get forensics involved to have a look at their devices to see what they were up to, because often you don't know exactly what's gone on, but you feel that something bad's happened, and we need to get that evidence as to what's happened. And it is possible, if someone's launching let's say a competing business using your materials that's confidential, that we can get an interim injunction. We have to act quickly. So if you detect something like this, it's really important to gather the evidence and act quickly. And that's the same with actually IP infringements. If you really want to stop someone quickly because they're an imminent threat to your business and you've only just discovered it, it's best to reach out quickly to get advice on that. And some IP rights, you need to word any cease and desist letter in a particular way, because otherwise they could say you're making an unjustified threat. So you could be facing a claim against you, which is why it's better to reach out and get professional advice before you just launch into sending a cease and desist claim, because they could also come after you with a claim. So if you get it wrong, it can create other issues. I've popped up on this website patents just to complete, but I'm going to skip through that because I don't have much time. But with IP, I've mentioned actually what the rights are and the importance of securing them, but you should also think about how you deal with your IP in your agreements. So a good example of this is if you get someone to create something for you as a contractor, let's say to design a logo for you or design your website, they will own the IP in what they've created unless they expressly assign it. So it's important that we check that your contracts do what you hope they would do, which is assign the rights to you. Now, franchise agreements, that is also something to think about. And again, to think about your IP. So, you know, exactly what is, if, for example, with the license for one of your franchisees to use your branding, you know, what's the territory, what's the duration, any restrictions, the need to comply with your branding guidelines, strict rules around social media, what happens when you exit, if you'd want them to obviously stop using your branding and your materials, and you'd want to manage the misuse of any potential confidential information like your student lists. You'd also probably want non-compete clauses so that they couldn't solicit your tutors or your students. All of these things are important contractual considerations to think about. So to wrap up, because I'm conscious we're running out of time, just a few top tips. I recommend auditing businesses, and I've used the example here of a Jenga. Like, often there are gaps, and there can be simple things that we can do to plug those gaps. So that is an important first step if you're thinking about protecting your business and your IP. I've mentioned before about relationships. That's another area to think about. So do you have a good IP clause in your contracts with contractors, employees, you know, key collaborators? How are you dealing with your IP to make sure it's not misused? Another top tip on confidentiality is that just limit sharing as much as possible, and only share with those who are trusted and absolutely necessary, and make sure that you've got a good confidentiality agreement in place. So often an NDA, or if it's, say, an employee or a contractor, you should have quite detailed confidentiality provisions. And also, just if you are going to give someone a document, make sure it's headed strictly private and confidential. I mean, that is a very simple thing, but it just goes to show that you consider it to be confidential, so there can be no misunderstandings there. I've mentioned about monitoring and enforcing your rights. I've mentioned, and this slide just captures that and what we can do with enforcing. One thing that I just like to flag there is with IP, there are special forums and special courts for IP, and there's one called the Intellectual Property Enterprise Court. Now, when anyone says litigation, people often get concerned that it's going to be very expensive. The good thing about this IP court is that it's designed for small and medium-sized enterprises, and they streamline cases to make them more cost-effective. There's caps on recoverable costs. So there's lots of different ways, which means it's not as terrifying in terms of costs and, well, mainly costs, as other forums for disputes. And that's it. So I've managed to leave 10 minutes for questions. Any questions?
I think there is a legacy question still in the chat. So Julia asked, who should you inform if someone copies your website or logo? I can't remember if you covered that already, though.
Who should you? So that goes back to the slide, which is that, first of all, we need to have a look at like what causes of action are available to you. But an obvious starting point would be to write to who's behind the website and ask them to take it down. And also, you can also write to the search engines such as Google and request that it's de-indexed.
And then Julia has asked, so Julia Delamer has asked, could we talk about fonts and colours into trademarks? And then I think
fonts and colours was that?
Yeah, fonts and colours.
Yeah, so that's possible in a nutshell. We can do that. You can file for a word mark in a stylized way in a particular color, for example. The only thing with that is that if you later change your color or your branding to something else, you then need to file for another trademark. So that's just something to consider, because you literally will have protection for what's on the register.
And Stephen, I think you put your hand up at one point, but you've lowered it if you had a question.
Yeah, sorry, I can't find chat on here. Thank you for taking the question. I just wondered if you could, Lucy, expand a little bit on this whole business of, if you're trying to have a title for your business, but you're including in that the actual purpose of it or the nature of it. What are the limitations there? For example, if you were using a word like tuition or coaching or mentoring, what probability is there of it being rejected because that is within the overall title? Thanks.
Quite high from X. But the one thing that I would say, there are clever things we can do to try and get around it, but it is quite hard if you've got tutoring and you'll want your trademark to cover education. That's always going to be difficult. And you might come back to me and say, but look, there are some marks that are already on the register. And that's because the UK IPO can be quite, but basically they've really clamped down more recently on these descriptive marks. In the past, we found that we've been able to get some registered, but the practice has changed. So sadly, we're finding that really difficult.
And then in the chat, Charlotte and sorry, showing as Saltera, but I know it was not Saltera. Anna, yes, thank you. Are asking about, would you suggest we purchase the name of our website with .co.uk and .com to protect ourselves, and also similarly Instagram accounts with similar names? I already suggested in the chat, definitely yes.
Yes.
And I was also just in the middle of writing a comment about a good example would be for the TTA. So obviously we have had the National Tutors Conference for some time, but a couple of years ago, somebody else thought that they would create a National Tutors Conference, and we did not own the domain name, and we have, fought as much as we could, but obviously there is a limit to how much you can fight. So definitely, I think just any cost like that, I would see as insurance rather than anything else. But maybe Lucy, you have more to add.
No, I 100% agree, Sam. Definitely get them secured. And with things like Instagram and the like, maybe you're not quite ready to use that, but if you've got it, if you've got it secured, then you have the option, and then you don't fall into these nasty spats along the way that cost money, which no one really wants to be involved in. What if a Facebook page exists with your name? Can you do anything about it? I suppose I think that one, Charlotte, if it was so with trademarks and branding, it's all about basically who was first to use, and the system also relies upon first to file. So I suppose in that scenario, if your business name was out there before the other side and they've launched something recently, well, not recently, but 2022, that's the same or similar to your name, you can ask them to stop. And you can, in that case, with Facebook, you can use the online takedown forms that they have, again, but it'd be better if you have a registered trademark. And again, because of this groundless threats, it is important that it's worded in the right way. So you might want to gain professional advice on that. Hang on, another question. If a business already exists with, let's say, super smart tuitions and is not registered, can I register a mark with Super Smart Academy and be at no risk? So first of all, that mark, Super Smart Academy, super smart, is likely not to fly with the UK IPO. They'll say that that's descriptive. But let's say even if it did, let's say even if it was accepted and we did get a trademark for it, it's very similar to the other side. So they could potentially claim that you're passing them off because they don't have a registered trademark. But if they can show that they've been using their brand extensively, that comes back to, if you don't have a trademark, what can you rely upon? And that's passing off. So that's risky to do that.
Any more questions?
Oh, here we've got caught out before. Hang on. So, example where someone was caught out before, the name was previously Brilla Languages and used a business. Brilla Travel messaged me asking me to change my name as they had rights in the word Brilla in education. What happens? Okay, because it means fluency. If I register Salutra and that means fluency in Spanish. I mean, I would say that in that example, so where, for example, you had Brilla Languages and someone had Brilla Travel and they had a trademark for educational services, you can see that potentially that has merit from a trademark infringement perspective. You know, yes, you've got languages and they've got travel, but those two parts of your marks are not likely to be distinctive. So actually the dominant and distinctive parts that we're comparing are actually Brilla and Brilla, and those parts are identical. So that's why they'd be able to say that that it infringes. And then with Soltura, and if that means fluency in Spanish, I would say that in terms of descriptiveness, that's not highly descriptive. Perhaps it alludes to some of the qualities of your services, like come to me and my language courses will make you fluent. But I wouldn't say that that is as high risk as other examples like tuition for tuition that we've been given so far. And another thing to remember is like what percentage of the British public actually speak Spanish, because that also is a relevant consideration and therefore would understand that the term means fluency. I love all these technical questions. Any more? Oh, we've got more. So here, personal names, yes, they are capable of protection. And that is something to think about. And random ones, yes, the more, if you go for something more random, less descriptive, you're more likely to get that mark. But also it's the point about you know, if you've got tuition in education, to enforce that right, you're going to have a big budget, because you're going to have to technically, if you really want it to act as a trademark, which is a monopoly right to stop others using something similar, you're going to have to stop everyone that steps on your territory. So it also makes sense, not just because you're more likely to get that mark, but also from an enforcement perspective, it will be cheaper to police your rights if it's something that is quite distinctive and not commonplace. Okay, there we go. I think that's everyone's questions. But look, you've got my details, and Sam also has my details. So, you know, I'm here to help in any way that I can, answer your questions. Yeah, and I'd be very happy to help. I've got one question here about, is LLC only for the US? That's the abbreviation for US companies. We can also, by the way, file global marks. So yes, I'm an English lawyer, but we manage portfolios internationally. So if you are going international, we can help with that too. Is that all good?
Yeah. Oh, and one last question. What about initials with name? I looked into it as my initials are ASMR, and apparently this was refused as a trademark. Isn't ASMR that like tapping thing as well? You know, the videos where they're like, listen to me.
Probably why it was why it was refused. We see loads of acronyms like qualify for as trademarks. So there's not a bar against acronyms. They just will. It's just a case of checking to make sure no one else has something similar.
Amazing.
Good.
Thank you so much, Lucy. This has been such
Thank you, Sam, and thanks for inviting me along. It's I hope everyone's found it helpful.
We really appreciate your time. For everybody that's been watching, I will send you the link to get your certificate and the link to the recording within the next couple of days. Most likely it's going to be next week now, because we are on the straight and narrow down to the shortlist reveal party on Friday for the National Tutoring Awards. If you aren't registered to come and attend and see who's made the shortlist this year, please do. We're going to be playing shortlist bingo again. It's going to be the most fun. And yeah, it's just a really great afternoon. For anybody who's watching the recording, you can find a lot of other videos of other CPD lives on our YouTube channel as well. And if you do watch a session live, that's how you get the CPD credit and the CPD certificate. So thank you so much, Lucy, and have a great day, everybody. Bye.
Bye.